Hello, this is Tom Higgins. The topic I'd like to cover today is appeals. They are a very different animal in criminal justice. Appeals are what is filed after a trial that has been lost. It is not post-conviction relief. It is not habeas corpus. It is a direct appeal. There are set deadlines that have to be met when the notice of appeal has to be filed. And then there is a scheduling order from either the Court of Appeals or the Supreme Court that determines when the briefs have to be done. That can be moved. It often gets moved because of a very large trial, very complicated issues. But you look at your opening brief is usually due within 4 to 5 months of the filing of the notice of appeal. The issues are mistakes made by the prosecutor or the judge. Recently, several cases have been overturned because of prosecutorial misconduct, commenting on things, for instance, like the defendant's right to remain silent. And the judge is also looked at by the Court of Appeals or the Supreme Court when they look at the issues about rulings on evidence, either sustained or overruled, but those are rarely used for new trials. Jury instructions are very big now on getting cases reversed. The prosecutorial misconduct is getting to be more of an issue, and I have no idea why that is, but it's being raised more and more in appeals. Appeals can take from 3 to 4 months to a year, easy. They are expensive and the costs are a lot, but you can find out by visiting our website or calling our office, and we'll probably schedule an appointment. But remember, deadlines are running. You have to file a notice of appeal within 20 days, and a lot of times people come in when they get their transcript, and basically it takes some time to go over it. Days worth of transcripts probably takes about 4 to 5 hours to read. So there's a lot of footwork to be done before the opening brief is filed. We have lawyers and law clerks working here, both for the law office of Maggie Schmidt and mine, the law offices of Thomas Higgins. And we also, from being in the business for almost half a century, have a huge data bank of briefs and things to help. So we're a little more efficient than the average law firm, I would think. The questions on appeal, people think that filing an appeal and what they think are flaws in the case should be really easy. They're not easy. They're very time consuming. The state gets a chance to respond in what's called the answering brief and say, well, we are wrong and they are right. And then we do a reply brief answering the states. Now, the Court of Appeals can do a bunch of things. They can grant it and send it back for a new trial. They can grant it in part, for instance, and send it back for a sentencing if there was a mistake. They can send it back for a new finding of evidence. There are lots and lots of remedies that the Court of Appeals has. The only thing they don't have is a deadline. And the deadlines apply to the prosecution and the defense, but not to the courts. They can take as much time as they deem necessary, or depending on their workload, they can do. And so sometimes it's a long time to get it out. Now, you cannot go into federal court with a state conviction unless you first exhaust state remedies. In other words, you have to give the state every chance to correct its error before you can go into federal court on a habeas corpus. And in fact, it's called the exhaustion rule. You have to give them every chance. Now, if you file an appeal, it's denied. You file a petition of review to the Supreme Court, it's denied. You're done. You can go into federal court at that time. So you can find all this out by giving us a call or visiting the website. Thank you.